Hello there, and welcome to the Michael Calderin Show. We're so glad that you could join us. It's been a while. It's been since last year because now we have entered 2025. I'm really excited about the guest that we have today, Jacqueline Love, who is a local attorney, and we're going to be talking about a very, very important topic. Um, so before I introduce Jacqueline. Is it all right? Do you prefer Jacqueline or Jackie?
Jackie's perfect.
Jackie? Okay. So Jackie is a managing partner and co-founder of Legacy Law Firms. And we're going to talk about the type of work that she does, as well as some of the important things that we need to be looking at in our own lives, because we're not going to be here forever. And we've certainly talked about that quite a bit on this show. A little bit about Jackie's background. She is a native of Miami, Florida, holding a Bachelor of Science from none other than Nova University right here in South Florida, double majoring in legal studies and criminal justice. So she's a bit of an overachiever, and receiving a minor in international law. She continued her studies in law, graduating from Nova University Shepherd Broad School of Law in 2013. That was at the age of 12. And she was admitted to the Florida bar in 2014. And hence that started her career. Her family stems back to Cuba, where her grandfather, in his final year of schooling to become a lawyer, when Fidel Castro came to power, and he was forced to flee with his family to Miami. So that created the family transplant here, right? And we're glad that you're here with us in South Florida, Jackie. So welcome to the show.
Thank you for having me. I appreciate it. I'm honored to be here.
And thank you for being here. And I know, we've been trying to set up having you come on the show, but of course, it was the holidays, right? We had spoken, I think it was right before Thanksgiving, and Thanksgiving, and then there's Christmas and New Year. So we're making it happen now for 2025.
That's
And
also a great start.
I always, one of the things I do, as you know, I officiate at a lot of weddings, and and I also provide premarital counseling to all of my couples. And one of the things I talk to them about is things about advanced medical directives, right? We learned a lot from the Terry Schiavo case, which happened here in Florida. Remember that? And they're probably talking about it in law school when you were there, right? And I talk about, wills and trusts um, at no at no level of real proficiency do I talk about wills and trusts, which is why you're here today, because I do encourage them to seek legal counsel and to make sure that they have the necessary paperwork in place. Because, as we know, the marriage license alone is not sufficient in certain cases. And I've always heard that you don't want to wind up in probate court because that's a grueling process, if you will. So let's just jump right in, right? And let's talk about. Um, so we've heard of last will and testament, but then there's also something which is a trust. There's a living trust, and I understand, and this is my limited knowledge. So the one thing I know is that one can be challenged and one cannot be challenged, and maybe that's not even correct, but I'll turn it over to you, Jackie.
Okay. So I'll even, if I may, I'm going to kick it back a couple steps before that, because something I get a lot of will be a phone call of someone interested in getting a will. They always mention a will. And what they don't realize is estate planning is not just a will. It's a will and about 4 or 5 other documents. So it's not just one document. They go on to LegalZoom. They're trying to do a DIY kind of thing to save money. And what they're not realizing is that one term that they've heard about from their friends or the internet or Google is a misnomer because it's actually several documents compiled into a package or a plan or portfolio that serves to protect them in different circumstances for one robust protection. Um, so for the most part, when you hear the term will, you're thinking of the last will and testament.
Right.
And there is something called a living will, which is what stemmed from the Terry Schiavo case in Florida. You also have very specific laws in Florida with regards to estate planning and technicalities that make a last will and testament valid. So there's so many different components to it. We try to do it the way we practice in our firm is to create a robust overlapping kind of gridlock protection in different components. So medical, financial, planning for minor children, planning in terms of creditors, asset protection. We build all of these different layers so that they're overlapping in a way where just in case something is ruled invalid or a provision is invalidated in court later on when you're not really around to fix the problem, we have
Right.
other aspects of it that are going to then kick in to protect your estate, your beneficiaries, and your wishes ultimately. So it's a robust compilation of all these different aspects. There's healthcare directives, advanced directives, durable power of attorney, which is one of the most important documents, I believe. The last will and testament, the living will, like we mentioned, pre-need guardians, and then something that you mentioned, the revocable trust is often a huge component in that. So that kind of gives you a little bit of that background. Now, we do one of two things usually. We will do a will-based plan for our clients in which it's just that package, those documents without a trust. If a trust isn't the necessary component for their needs, if they are not concerned about avoiding probate or finances are a little tight because it's a little cost, it's costly to create this kind of a plan up front. Now, we do that without a trust and we do the will-based plan with a trust in different circumstances based on the client's needs. And it really is a case by case circumstance that you got to dive in and understand the financials, the assets that we're talking about, the age of the beneficiaries, the complexities behind what you're trying to achieve. So in a last will and testament alone, without a trust, you're going to eventually, it still needs to be admitted into probate. The will itself is a public document. So it's something that you're not going to be able to have that confidentiality component honored. It's going to be filed in the public record. So anybody can go to the courthouse and go and download or ask for a copy of someone's will that has been deposited in the repository. It's a
Uh,
public document.
So I just want to clarify something.
Sure.
Someone dies, they have a last will and testament. It still has to be filed in the clerk's office,
Correct.
regardless of the situation.
Correct.
Okay.
So statutorily, it should be done within 10 days of the person's passing in Florida.
Okay.
However, oftentimes not often, you need to file it with the original death certificate. And oftentimes that process takes a little bit of time longer in order to receive them. So
Right.
they offer a lot of leniency in those cases. So whenever you do get the death certificate, you file them together, but you do need the original will, and it does need to be filed. And it becomes part of the public record. So that's something that anyone can theoretically go and obtain a copy of.
Now, how about if the decedent is uh, one of those exempted parties under 119, former active or retired law enforcement, firefighter, etc. Would that last will and testament also be exempt from public record?
You would have to file it anyway, but in most cases, depending on the jurisdiction, you would have to file a different confidentiality document advising the clerk that that matter is pertinent to that statute and that is exempt under those circumstances.
Okay. 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 And that's kind of how it is now, like with deeds and other things. There's a separate form that folks fill out. Okay.
Right. So another component to the will versus the trust circumstance is on the will, everything that goes through probate, you're going to have to hire an attorney. And there's either a summary administration, there's a formal administration based on the value of the assets. Either one, you're still looking at a minimum of $3,500 to $4,500 in terms of attorney's fees plus filing fees. There's going to be a fee that could be paid out to a personal representative of the estate. That's a percentage of the value of the estate. It's going to add up very quickly. It's very time consuming. The court process could take anywhere from several months to several years. So just to get through the probate process, your beneficiaries are going to have to be on hold. They're not going to have access to those assets immediately. It's going to delay their ability to settle the affairs, and it's going to take a very time consuming, lengthy process with a lot of money being paid out in order to effectuate this. Whereas on a trust side, you are able to avoid having to fight because a trust is not filed in the public record. It is a confidential document, so you maintain confidentiality. So
Okay.
the trust itself is never filed. It is a summary or a certificate of trust that it kind of gives you the very, very, very spark notes of that trust, as much as what the banks would need or the lender or the court would need. That is a simple, oftentimes couple pages, 2, 3 pages document that gets filed in lieu of the actual document. So you maintain confidentiality. It is a much quicker process. The trust is it's costly to do upfront, but you're not going to have that 3% fee of the overall administration as if you had gone through probate. So overall, you're going to be paying a little bit more upfront to do, but you're going to have a lot more rewards and long-term benefit for your beneficiaries, for the estate, creditor protections, avoiding of probate, confidentiality, and a much more simplified process going through the trust administration process versus the probate administration process. So it's kind of something that people don't think of when they say that I don't want to have to spend the money now. I would rather do it later. Trust the probate process doesn't seem that crazy. Let's do this without a trust. That's usually what we explain to people so that they have a better understanding of the pros and cons of both. You're also going to have circumstances where if you have minor children and the minor children are now inheriting in Florida, anything above $15,000 in an inheritance or a settlement, they have to have a guardianship established. So you would want that to be ideally in a will, a pour over will, and a trust so that it can bypass that whole process. It kind of sets the terms for that up front, and you avoid having the necessity of going through a guardianship court. It kind of does it all up front and skips a lot of valuable steps that you don't, or steps that you already have done up on the front end instead of having to go through the process afterwards.
Okay. So basically what I'm hearing is um the trust is, for all intents and purposes, there are a lot more benefits to the trust than there is to the will,
Right.
right? Because
And though, that's
I'm sorry.
definitely work hand in hand.
Okay.
Normally, we'll draft the will and the trust at the same time because what we do is we use what's called, if we're doing a trust, we will use, instead of a normal traditional last will and testament, we will use what's called a pour over will. So essentially, it's like a big bucket. Very
Yes.
layman's terms, you're putting everything in this bucket, and in the event something was left out inadvertently, we are putting this terminology so that they speak the same language. The trust and the will speak the same language. They're in unison. They're completely in alignment in terms of your wishes and your beneficiaries and what you want. And if there's anything left out that's not funded to the trust up front, that pour over will then at that point dictate all these assets are intended, or if they are not already funded, we're going to pour them into that trust even after I pass. So it's like a catch-all that protects you even in the event of a mistake or something not being funded, or let's say you're investing in more properties or in buying businesses, or you buy a CD and you didn't add it to your estate or your trust and you didn't fund it over, title it over. This will speak the same language and give you that same protection, putting it all into the trust even at that time. So they
Okay.
work together and it gives you a really robust protection that in most cases is very beneficial to people to have long term.
So, oh, so you can actually have both documents?
Absolutely. We
Oh,
normally do it
okay.
that way.
See, I always thought it was one or the other.
No.
Okay, so you can
Usually,
have both.
yes.
And then in terms of challenges, family member X says, no, Johnny wanted me to also have, you know, his boat, and it's not in the will, or um, it's not in the trust. So can I challenge the will and not the trust, or how does that work?
So usually the trust is not the commonly anything can be challenged. You're
Okay.
going to have a higher propensity in someone trying to challenge a will when there is no trust because it's public record. Now this document is disseminated. There's no fiduciary responsibility as a trustee. You still have a personal representative managing the affairs and the process of paying the creditors and closing the probate process and distributing assets to the beneficiaries, but it's not the same as in a trust. So in a trust, it's already titled over. Everything is already funded. So that process of transferring ownership to the beneficiaries based on those parameters is it's much more simplified and it's much more streamlined. There's less challenge propensity there. It
Okay.
will be challenged, but not to the same degree as a will. And you're not going to have the creditor issues in the same way. Now, we're getting into kind of a strategy talk. Sometimes we do recommend that even though we have a trust, we might want to file in probate as well. That is a simple legal strategy that we sometimes work with our clients on because oftentimes, if you do file in probate, you get that creditor time clock that starts ticking away. So, from that point forward, once that clock has the sands on that clock timer has already run through, it extinguishes any creditor claims against that estate. So, it's kind of a let's talk, let's sit down, let's go through pros and cons. What are your biggest concerns? Do you have any of these issues? Do you have any of those problems? What are the big overarching things that you're trying to accomplish? And let's figure out what is the best strategy that works to accomplish those goals within the parameters of estate planning in the state, which is kind of the niche field of analysis, tax planning. We sometimes work with our clients with a CPA as well, because we want to make sure our clients have the best bang for the buck for their legacy to be continued into the future.
Right. Now, let's say Johnny has, you know, a will, a trust, but he's also got another account that's may or may not be listed in the will and the trust. But let's say it's a bank account and he has listed a specific beneficiary on that bank account. Um, but it conflicts, let's say, with something in the will or the trust. Any guidance there?
So beneficiary designations that are put through an account like that are going to trump the estate planning component. So they
Okay.
will automatically fund over. So if you have, like, for example, a pay upon death, a POD, or a beneficiary designation or a transfer on death set in your checking account, your savings account, let's say at Bank of America, those designations and that beneficiary assignment is going to take precedent over what you may have put in a will before or even after. It's going to automatically just go to that person. It's not subject to your estate. It's not a part of your estate at that time. It is not going to be something that is going to end up in probate to distribute. It's going to automatically fund to that beneficiary based on that designation.
So it might be a good idea if someone, financially is at a certain level, if you will, um, to maybe have an account that's separate with the designated beneficiary, which may or may not be the personal representative, right? Um, to handle some initial immediate expenses like funeral, things that kind of have to get taken care of right away before the other things are sorted out. Am I making sense with my question?
Absolutely. And that's a very good recommendation that we oftentimes make with our clients as well. And it's common, it's not something you want to think about proactively, but it's
Right.
So super easy to do. You can go to the bank, open a separate account, a separate, like a savings that you don't touch very regularly, even just maybe $5,000 in it. You put that title or the beneficiary designation or a POD on that account, give them that signing off authority. You add it to your estate plan and with your professional, with your legal professional. And now you have something that that individual can automatically step into at that
Right.
given time and take care of all the expenses, handle the filing fees, handle the legal fees, the funeral costs, all the different
A
pockets.
mortgage,
Right. Exactly.
property tax,
Um,
whatever.
that's something that we've seen where people will make a trust with a legal professional. We've seen this unfortunately more times than we would want to see because it's not what you want to assume is being done in the local area, but there's so many attorneys and they do things so differently. And it's not always the best way, not always
Right.
the wrong way. Sometimes it is, but not always. We do see where sometimes people will not fund the trust or the attorney didn't give them instructions on how to fund their trust or didn't inform them that it is just an empty vessel until you put the property and title it in the name of the trust. So they think that everything is good and God, later down the road, they pass away and the beneficiaries are stuck going through probate because there was a trust with that was not funded at all.
Right.
We've seen that. We've also seen estates where there's a trust in place and they have a homestead or a property, a real estate property in that trust. It's funded, but there's no financial or monetary funds to be able to pay the expenses of that trust administration or to be able to pay that mortgage or to be able to pay the homeowners or the homeowners insurance fees
Right.
and to handle the normal bills until it gets sold or the appraisal. There's so many little components that kick in, and at which point what you didn't want to happen, which is to require a sale, maybe they wanted to hand that property down to a nephew or a niece or a grandchild or a daughter or a son or a stepson, whatever the case might be. Now they're going to have to sell the house in order to be able to afford to pay the rest of the expenses and close out the administration. So we see a lot of those little nuanced details. It's always a good idea to think ahead. What would it take for a year's worth? If it took a year, God forbid, a good buffer is maybe 6 months. What would it take to for 6 months to be able to float that property?
Mm.
Bills, insurance, mortgage, the homeowners association fees, the appraisal reports, the administration process. Kind of summarize all of those costs, the utilities. And let's say it takes that long to sell, or it takes that long to resolve this. Put that amount aside with enough buffer to be able to pay the costs associated with the funeral and all these arrangements and leave that in a separate account already titled, ready to distribute POD or TOD at the bank. And that is always a good idea, without a
Oh,
doubt.
okay. And um, power of attorneys, right? There's a limited power of attorney. There's a durable power of
Right.
attorney. And my understanding, and again, correct me if I'm wrong, because you're the legal expert. Power of attorney terminates at someone's death,
Right.
right?
Right.
So let's talk about the difference between the two benefits to, benefits and pros and cons.
Okay. So in estate planning, you're ordinarily going to see what's called a durable power of attorney. That document is a very robust document. It's a very broad reaching, long term planning document that gives a lot of power. Other than practically, I say this to all my clients, they laugh, they think I'm kidding. Other than marrying you off and voting for you, it's going
Right.
to give that person the power to do a lot. So you have to know who you're choosing, giving the power to know if you believe and fully trust that individual to make decisions that are for your best interests, ultimately, without any concerns, and be able to decide if you want them to have all those robust powers so they can sell, they can acquire property, handle lawsuits and claims and insurance, pay your bills, access to all your medical, access to your financials. It's a very robust document. Durable power of attorney is going to withstand incapacity. It's still effective. It continues to remain effective even through a mental incapacity or a physical incapacity of a person, of an individual. Whereas the limited power of attorney is only for a specific purpose and it is not valid at incapacity. It's just for that one individual reason. So it could be to give someone the ability to speak on your behalf, let's say like a financial advisor speaking to an attorney for one particular thing, or to settle a lawsuit in this particular situation.
Like to transfer a motor vehicle or
Correct.
something like that, right? Because I know motor vehicles has a limited power of attorney that you can fill out to, you know, for the title agency to do the business for you or whatever, conduct the transaction.
There are taxes. So if you work with a CPA and there's an issue that they need to communicate with the IRS on your behalf, you have to do a limited power of attorney, giving them authority to speak on your behalf with the IRS.
Okay.
So,
Oh,
and it's just for that one purpose, just for that one limited purpose. And when that purpose is achieved, it is extinguished. It no longer remains effective. And if you were to become incapacitated during that time, it's not effective anymore as well. So the durable power of attorney is the one that you want to make sure you're doing and put in and have built into your estate plan. And we actually highly recommend, once if any of our clients or any individual has young children or
mhm,
even high school age children at 18, with the child, obviously the child has to do it because they're no longer a child once they turn 18. They're legal adults. We
right,
highly recommend that they have a power of attorney established, giving the parent, a parent or both parents, authority. Because God forbid something were to transpire, there's a medical emergency at college, or there's an act, you never know those what if circumstances. And
sure,
isn't guaranteed any wherewithal to be able to step in and help or make a decision or even be spoken to in some circumstances, because
true,
schools can and oftentimes do say, I'm sorry, we can't speak to you. They're an adult and you haven't been authorized.
correct, correct. And is it necessary for a married couple to have power of attorney for each other?
I would venture to say yes. You're going to have the one off circumstances where, as a spouse, you're going to be legally authorized to speak on each other's behalf. But there are circumstances where it might come into question, and you don't ever want to have that stand in the way of being able to make an important medical decision or an important financial decision on behalf of your spouse if God forbid the time comes where you need to.
Right.
So it's always important to have it in place, and we always build in backup, like a primary person, a secondary person, and even a backup, sometimes third person, because
Sure.
you never know. There's sometimes circumstances where it it's just the way that life happens, and both individuals, husband and wife, have an incident or an accident on the way back from their honeymoon. We had this case in Florida recently, or I wouldn't say recently, maybe 5 years ago. But you want to have that next person in line and the person after that in line, not just on the power of attorney, but on all your estate planning documents, so that someone else can then automatically be allowed to step in and make those decisions and take over and handle the administration on your behalf, especially if you have kids. That becomes another big topic.
Right. And can can a minor have power of attorney over an adult?
No, there are parameters. So you have to be an adult and in 18 or over. And ideally, in certain circumstances, you want them to be a resident. At least the primary individual should be a resident of Florida so that they can step in on your behalf, but they have to be an adult for sure.
Okay. And I guess that can segue into, a healthcare proxy or advanced medical directive
Right.
and appointing someone, as well as, having your own wishes, right? In terms of, do you want to be kept alive by artificial means, life support, et cetera, et cetera. Let's talk about that. And again, we learned a lot from the Terry Schiavo case. Um, I don't remember, healthcare proxies or advanced medical directives being that big of a deal until this case came out. You know,
Right.
um, I was just reading up on the case. Maybe it was a couple of months ago when I was actually counseling with a couple. We're doing some premarital counseling, and and I mentioned the Terry Schiavo case, and they had vaguely remembered it because they were very young at the time, but I didn't even realize that it had gone on for a few years,
Yeah.
that she was still in a vegetative state. I remember that her husband was already engaged to someone when they finally, did take her off life support, or stop the fee, whatever it was at that time. So let's talk about the healthcare proxy and designating a healthcare surrogate, if you will.
Right.
And again, I guess my first question on that also is, if you and I are married and one of us winds up in the hospital, can can the spouse make a decision without any healthcare surrogate appointment?
Most of the time, yes, not guaranteed, and it would be left to the facility. So the provider, the facility, their practices, you might not have that smooth of a time in doing that. And it leaves a little bit too much in the power of the medical professionals, which are dealing with a lot of different circumstances. They're overwhelmed. For example, during COVID,
Right,
dealing with an enormous influx of cases in a way and at a magnitude that they had never seen, but none of the world had seen before. So
right.
there was really no precedent on how to handle these circumstances. And to the best of their ability, they were trying to navigate all these circumstances where one parent, both parents, the spouse is there and are not legally married, but they've been together. The parents are no longer around. Who makes the decisions? How do we handle this?
Yeah, yeah.
And I remember this particular issue came up a lot during COVID, where they needed the beds. The condition was almost not something that the individual could come back from. They didn't know what was going to happen. It was just such a terminal life support situation where they were pulling plugs and there were orders to stop the pulling of the plug. It was chaos. And it's not something that we kind of saw coming. No, none of us saw COVID coming, but it really did teach the legal world and the medical profession and individuals the importance at a whole new level of estate planning and the importance of having it in place in advance proactively at all walks of life, at all ages. Doesn't matter. It's not a retirement tool. This is something you do proactively as much as having car insurance when you're driving. That's how important it is.
No,
Uh,
absolutely. And you know what, Jackie, I think at one time, like many other things, you know, you're young and you think, I don't have to worry about a will right now. I don't have to worry about advanced medical directives. I don't have to worry about a trust, you know. And I can tell you that I have unfortunately officiated at funeral services for people I've married. And the youngest at the time, he was 35 and had been married for 5 years. And,
wow.
again, if COVID and other illnesses have taught us anything, it's that, and cancer. I mean, I think there's a lot of people dying of cancer too. And if it's taught us anything, it's that death does not discriminate with age. There's no age discrimination with death.
Yeah.
There's no discrimination, period, right?
Yeah.
So I think that young people really need to take this to heart, as just like older folks, the importance of this. I know that the last time I had a procedure at the hospital, it was part of the admission packet for me to
Right.
assign a healthcare surrogate and a backup. And a
Okay.
backup. It was at Cleveland Clinic here in Weston, and they had right there, when you're signing in, they have the different forms available, healthcare surrogate and everything, and it's part of the admission packet, so that there's no question. Doesn't matter your marital status or anything. Here's the form. You designate whoever it is that you want to make those decisions.
So, as great, and I think that this is a move in the right direction. And it's good to have this in place and have this available and require it as part of the admission process. But if you think about it from that experience that you had, you're already and you're prepping for a procedure. So oftentimes you can't eat, no food, no drinking, you're nervous, your nerves and anxiety are through the roof. You're not exactly in your prime mental capacity to be processing some of these tough issues. And you just really just want to get in and out, and you're just praying you make it through. Because
Right.
it's not, no matter how complicated or simple the procedure is,
Right.
it's never something you want to do. It's never something we want to do, ever. So
Right.
that's not usually the time you want to be learning and reading about a living will or a healthcare proxy or a healthcare surrogate form, in other words. You want to do that proactively with a legal professional that can guide you as far as what are the options here. Because
Right.
those forms are basic statutory forms, but you're not going to get the same understanding, the same guidance, the same level of detail and protections in place that you would with an attorney that's they're hired for you for your best interests, that's going to help you see all the potential what ifs and what is available to you in this one document versus a template that the state provides to these facilities. So it's good that it's there. And if someone doesn't have that planning in place and hasn't really considered it, it's better than the alternative of not having it in place. But it's not something that I would recommend, like, let's say for my family, I wouldn't recommend that they go that route. I would recommend that they do planning in advance of that professionally, just because you're going to get the most robust protection and understanding that you're not going to get in a quick form in the middle of that heated moment.
Right. And I guess the healthcare surrogate form, does that also kind of die with the person if they die?
Essentially, yeah,
Okay.
that is correct.
I do remember um, when my father passed, and I was his healthcare surrogate. One of the things that was in that paperwork, and I don't even remember where the form was from because this was um, 20 years ago. It did add in there the authorization to dispose of his remains. Is that something that's standard in a healthcare surrogate form?
It should be. And again, it depends on the legal professional or the facility that's doing the form or creating the form for you. So for us, it is. We go through it with our clients. So there's going to be a living will, which is the one that came about from the Terry Schiavo case. You've
Right.
a form, which everyone knows the word HIPAA, so we all should be aware of what that means. And
Right.
it goes hand in hand. They kind of overlap, that same overlapping protection. And then you're going to have the healthcare surrogate form, which is I'm going to give this person authorization to step in on my behalf, request medical records, make medical decisions on all things pertaining to my health and medical background, all the things that pertaining to me. So you've got the living will, which is going to say if this transpires and a medical professional says that I am incapacitated, or and there's very little probability of me making it out of this. I want these factors to be considered. And under these factors, I want you to do X, Y, and Z. I want you to pull the plug, provide feeding tubes and nourishment and IV and these things for X amount of days, weeks, months. But it's your wishes. And at this point, I want that to be pulled. This is how I feel. I want this to be authorized. I want my remains to go here. I want them to be donated. I do want an autopsy. Things like that get built into those documents for you so that as best as possible and as clearly as possible, they have instruction to honor your wishes. It's not left to chance.
Got it. And I guess one of the things you mentioned, and it just triggered another question, and that is, our Florida driver's license, right? We have an option to be an organ donor. So, and I'm an organ donor. And let's say Johnny is an organ donor, gets into an accident, driver's license says he's an organ donor, family member, maybe even the healthcare surrogate that's been appointed says, no, we are not donating Johnny's organs. Is there any, well, I guess no one who would fight that, right? I mean,
If someone would have to dispute it, let's say a beneficiary knows or a child knows that that's mom or dad's wish, they can dispute it and say, no, that's incorrect. But ultimately, if there's estate planning done, it would have been mirrored. So if I went to the lengths of putting it on my driver's license because it's important to me, I'm going to make sure it's in my estate planning documents. And at that point, that document is going to go to that individual, that representative making that decision for you, and it's going to go to the facility. So it should be communicated properly where your needs and your desires are being honored. That's the goal, the
That's
ultimate.
a very good point, that the documentation should mirror other things, right? Whether it's the organ donor indication on the driver's license or something else, those documents should all be consistent.
Correct. They should be in alignment together. So it's that overlapping protection where they speak the same language. So ultimately, we're not talking about a he said, she said, or the circumstance where something falls through the cracks. It should be thorough and the attention to detail should be there.
Okay. And I just want to clarify something else, because a few times you mentioned legal professional, right? So are we saying attorney?
Yes.
Okay, okay. I just want to, because obviously sometimes there's people out there that advertise, you know,
Right.
some type of legal advice, and they may not be an attorney, a licensed attorney. So I just want to be clear that
Yes.
it should be an attorney. It should not be a notary,
Right.
you know.
It should
The
be
notary certainly work with an attorney,
without a
but
doubt.
should be the attorney that is providing the guidance, the counsel, and the representation.
Yes.
You
And
know,
especially when it comes to estate planning and probate. So if you think about it, your estate planning is the proactive approach to this, and it's going to serve many different benefits, not just avoiding probate. It's going to serve to benefit you from a creditor standpoint, tax standpoint. It's going to serve to protect you and even potentially help you build in your assets and your bubble of estate, the value of your estate. It's also going to help you medically and your decision making power. God forbid there's emergencies. There's a component that helps you with if you have minor children, which is extremely important. And I want to make sure we cover that before we end today, because that's
sure.
something I think a lot of parents with young children aren't aware of in Florida. But as we go into that conversation, if you don't have all these different pockets in place, you're you're going to run up against essentially you're by the time this kicks in and it gets disputed or it's in court and there's a conflict, you're not around to dispute that. You're not allowed around to confirm the validity and the accuracy of the information on that document. Or if you
Yeah,
don't have that planning in place, it becomes pretty much ripe for a huge conflict between family members. And oftentimes that's what happens. And it takes a lot more money to be able to go through the administration process. So there's a lot of things that go into play, and you're not going to be around to answer and clarify those things. So ultimately, you want to take the front end, the proactive approach, so that you're here. And Florida law is so specific. Florida law is very unique when it comes to probate on that back end. So when someone does pass away and they're trying to have the court administer and assist in overseeing the distribution of assets to the beneficiaries, very particular subset of rules. And on the front end, on the estate planning side, Florida has very particular subset of rules on what is a valid will, what is a valid document in these components, how it's effectuated, how they sign it, how many witnesses, how many different the relational component of a witness and a notary. Very specific rules. If you're going to use a notary who's not aware of the current trends and decisions and appeals in Florida courts, you're going to end up, not only is it not going to be the best advice that you're going to get, you're going to potentially cost all of it could have been done for nothing because it's not going to protect you the way that you think it will.
right.
You run into circumstances like that all the time where people are in probate because someone, a parent, a relative, an aunt, an uncle, a grandparent went through legal Zoom or just wrote it on a napkin. I
Yeah,
did this XYZ, and now all of a sudden that's how they distribute their ad. That's what they thought was going to work, and it's not. So now they didn't realize they have to spend 3% of the entire value of their estate in a legal fee just to get this process taken care of in probate court.
Right.
Had they proactively handled it, they would have saved that fee and they would have only had to pay a fraction of that. So
Right.
there's so many things that you don't know what you don't know until you know it, until you're forced to know it.
Right.
So on the proactive side, even getting this information is so important. I love that you're doing this because people don't understand that this kind of planning is going to save them a lot of time, headache, money, and a lot of steps in the future. It's
Absolutely.
proactive planning. It's going to help them ultimately.
Yeah, and you know, I know you had mentioned about, the children, and I know you wanted to. So I know if you are an adult and you have minor age children, then one of the things you want to make sure that you specify in a will and trust is who will be designated as a guardian of your children.
Correct. And that's extremely important. It's called a pre-need document, pre-need guardian document. So in Florida, if both parents, if something were to happen, which again happened more commonplace than we wanted to even consider would ever transpire during COVID. And this really hit the fan during COVID, and it put us practitioners in a frenzy trying to figure out how do we fix this? How do we help people? And I
Right.
know during that time, I was doing free pre-need guardians for single parents because if you have minor kids and you don't know that this is a law in place and these are the protections you need to protect your kids, you're not going to be, if you're not aware of this, your kids can be, they could end up in state custody if God forbid something happens to you. And in the interim, they need to go through the court has to go through the process of appointing and determining the appropriate guardian of your kids. So it
Right.
puts kids in the front line. That's something that a lot of people don't even know is the process. You assume as a parent, you have minor kids, something happens to you and your spouse, God forbid. You assume your mom, your dad, your sister, your brother are going to be allowed to step in automatically, come pick up your children, and now they are it's traumatic for the kids. It's traumatic for
Sure.
everybody. But you think that that's the normal natural transition, and it's not in Florida. In Florida, the court has to appoint a legal guardian and determine who, within the certain rules and parameters, is in the best interest of that child and who is an actual meets the parameters of a guardian and based on Florida statute. It could be your mom or dad or brother or sister or the aunt or the uncle, or they could rule that it's going to be a complete stranger. It's really up to the judge to determine the best interest of the child based on the parameters that are in there in that given moment. And it's in guardianship court. And that could take time. So in the interim of that, your kids are not just going to be hanging out with grandma and grandpa, they're going to be in the state custody. So your
Oh,
kids now in the middle of all this traumatic event and all of this trauma that they're experiencing emotionally, they're devastated. They're going to have another layer of devastation, another layer of trauma to have to unwind and unravel because now you've just taken and pulled away not only their parent, their caretaker, the love that the pain that they're experiencing, but now they're completely feeling unstable. Their entire worlds are upside down and they don't even know where they're at. So the trauma that's done to the kids at that time, the courts they work as quickly as possible and they work with great people and they vet the foster care parents very well. I happen to know some amazing people that are foster parents that are heaven sent. But it's still traumatic for kids when they don't know the individual. And that
sure. Yeah.
be avoided. As a parent with minor children, you need to have a pre-need guardian in place for your minor kids, no matter what. No matter
Absolutely.
if you don't want to
Uh,
consider estate
You
planning,
know,
do that.
I know I always just figured, well, either a grandparent or aunt or uncle, if both parents perish or something, you would think, okay, then it's just a sibling of the parent or the grandparents. They just come in and take the kids. But no, there is a process. So really, I mean, the smart thing to do is to be proactive, get all your ducks in a row, have all these documents in place. And I'm
Right,
sure, depending on the situation, that will determine what people's investment is, right? In terms of what they'll be paying for for this type of package, if you will, right?
Right.
Whether children, there's no children, how much assets are in place, how many homes, et cetera, et cetera. Um, and I mean, we could go on and on for hours about this. I mean, I feel like we've barely scratched the
Oh, yeah.
surface,
There's a lot, of course, there's so
but
much. There's
but
so much.
I know for me this has been very helpful, um, because I thought I knew something. I really don't know much about this, but that's why you're here as a special guest, because this is your area of expertise, you know. Um, and and my guess is we're probably going to have you come back, because I have a feeling there's going to have to be a part two to this, Jackie, because I
Oh.
think we're going to get a lot more questions now on part one, and I'm chaplain for a few, for a few groups, both active and retired first responders, and I know they're all scratching their head right now, thinking about the things they need to do to protect themselves and their families. What's the best way? What's the best way to reach you if someone wants a consultation?
Absolutely. Well, it's super simple. They can visit our website, which is modernlegacylaw.com, and or they can call our office and they can schedule them for an automatic consultation at the convenience, that shared convenience. So it's easy during the day. We're flexible with our hours and we try to work with everyone as necessary because our clients sometimes are first responders, sometimes are teachers, sometimes they're business owners that are traveling to other countries where the hours are completely shifted. So we try to work with everybody as much as possible to make sure that they're able to get some quality time to answer these questions and go through their particular facts to help them and give them that strategic guidance that they would need for their unique circumstances. But they can reach out via the website or they can call our office, which is 954-999-9683. And I'll share the link and all the information with you as well. I don't know if there's a way for you to post it, but you can do that as well. And my email is jackie@modernlegacylaw.com. And anyone can,
Jackie at modernlegacylaw.com. Okay. And it's
we're
954-999-9683.
correct.
And is there an IG page for the firm?
It is, and it's Modern Legacy Law as well.
So on Instagram, Modern Legacy Law.
Yep,
Okay,
absolutely.
perfect. Any closing comments?
I
Any
think
closing arguments, counselor?
no, I think the important part is what I try to do with my clients to get them starting to think in the right direction is, what are your goals? Is it a financial protection? Are you trying to make sure you've got the best bang for your buck to grow your legacy and protect it from creditors? Or are you just trying to protect yourself in the event of a medical emergency? Are you trying to protect your kids, or are you trying to do it all at one time where you want all of this? You want to decide where your things go, your assets, your wishes medically, and you want the financial protections in place now strategically so that the benefit goes to your children. There's
Right,
kind of that frame of thought of, what are your goals? If it's all of the above, then it's all of the above. Then we go straight to it and we start diving into the strategies and we start planning with you. If your goals are more from the parental, I have young minor children or special needs children, or I have individuals under my care that have special needs, we work with them on that factual basis to help them develop the strategy to hit those concerns initially. If it's financially, we sometimes will work with their CPA and then kind of go through, or even if it's sometimes they're in investments, if they're investing in real estate and they're flipping properties or investing in different types of businesses and they have different structures of business interests and income flowing in from those business structures, we can come in and help them with that business structurization. So creating a minimal liability plan and strategy that feeds into your estate plan so that it continues to grow with while minimizing the risk to you. So there's different things that go in place that happen behind the scenes to help you and whatever your circumstances are that are tailored to your unique needs. And it's important that instead of avoiding the conversation, if you tackle it head on, from the front end, it ends up saving you a lot of time and a lot of money. It's not the most pleasant conversation, but our office will make it as comfortable and smooth and create that level of confidence for you that you definitely are going to appreciate in the future. So you'll know that you'll be taken care of and you won't have to worry about it. It's like that insurance plan. You want to have
Right.
it in place and you never want to need it, but you want to know it's there. God forbid you do need it.
Exactly. Well, I want to thank you so much for coming on, and I look forward to continuing our discussion, as well as, possibly having you come out to speak to a few different groups, because this is such important information. I mean, I can't thank you enough. It's long overdue for many. I know for myself as well. I have a will that was done many, many years ago that, is definitely in need of fine tuning.
Absolutely.
And um, and
Is
I'll
the
tell you what, I'll be reaching out to Modern Legacy Law Firm.
Absolutely. And I'm honored and I would love to help. And that's what we're here for. We want to help our communities strengthen from the inside out because a lot of our families were families that built their legacies from the ground up. And
Sure.
we know how important and how much effort, blood, sweat, and tears goes into these things and into our businesses, into our families. We want to protect our families. We want to protect kids. We want to protect our elderly. We want to set things up for each other in a way that continues to pay it forward for the future generations, not just gets tossed by the sidewalk, by the sidelines when that day comes and we pass away. So we want to help the community, we want to help individuals and families, and that's the passion that drives us behind this. So whatever we can do to help, we're here and we would love the opportunity to help as many people as possible.
Thank you so much. That's
Absolutely.
another episode of the Michael Calderin Show. We're so glad that you could tune in. If you want to listen to a previous show, you can look us up on Apple iTunes or Spotify, the Michael Calderin Show. We have started uploading some of the shows on YouTube, so you can also see some of the shows there. But a majority of them you'll find either Spotify or Apple iTunes. We thank you so much for tuning in. If you have any questions or comments, definitely send me a message, and definitely check out Modern Legacy Law Firm, modernlegacylaw.com. Thank you so much.
Thank you for having me.